just a second. All right, there we go. Hello. This is Chris Berry, a certified law attorney and certified financial planner with Castle Wealth Group. And today, just like every Wednesday, we do our weekly wisdom webinar where we answer legal, financial, and tax planning questions that have been submitted either over the week or submitted on the fly today. So if you do have a question, please put it in the Q&A. And I always like to start with a positive focus. And my positive focus is that we've added a couple of new team members over the last couple of months. So we have a new attorney, Ryan. We have two new CSCs, Christina and Brandy. We have a new paralegal, Carol. So we're really in growth mode, and I want to thank everyone who's worked with us for helping us get there. So with that, we'll go ahead and get started. I'm at one of the satellite offices today, so we're going to do it a little bit different. But first question here. I have a legacy trust for my son and daughter. Our assets are 50% in mutual funds and 50% in IRAs. My question is, can the IRAs be in the trust? The answer is sort of. So with a trust, the trust can never be the owner of an IRA. So any type of qualified accounts. So qualified accounts, things like IRAs, 401ks, Roth, you have to be the owner. Now, what you can do is you can pay the tax, take it out of the IRA and invest it in something else where now the trust could be the owner. But you have to be the owner of the IRA. But if you have a trust, you name typically spouse as the primary beneficiary, then the trust is the contingent beneficiary. So the trust can own inherited IRAs and inherited Roths. And typically the reason we do want this, because we can maintain the 10-year stretch for tax purposes with the trust, because that's the maximum that inherited IRAs can be stretched out for tax purposes. But also you can build an asset protection for beneficiaries. So there's really no, especially with our types of trusts, there's no reason why you wouldn't name the trust as the beneficiary. So typically, if you're married, you would name spouse first, then your contingent beneficiary would be the trust. So can the IRAs be in the trust? Your IRAs cannot be in your trust. You could pay the taxes on it, pull it out of the IRA. And now if you had it invested in XYZ mutual fund instead of the trust, you could have it invested in XYZ mutual fund. Or if you had it invested in XYZ mutual fund inside of the IRA, you could have it invested as XYZ mutual fund inside of the trust if you wanted to, with your money. But when you leave it to the next generation, that's where you can name the trust as a beneficiary. And now they can open up an inherited IRA in the name of the trust for the benefit of son or daughter, that type of thing. So yeah, the big thing here is beneficiary. We name the trust as a beneficiary. Yes, we can do that, and there's advantages to do that. And I see some people push back on this. That's just because the trusts aren't well drafted sometimes, and it could trigger a 5-year payout for the tax purposes. But our trusts are drafted properly. So that was question one. Okay, I have another question that came in. And I really only have 2 questions this week. So if you do have any questions, or feel free to type them into the Q&A. Because otherwise, it's going to be a short call this week. Let's see here. What just came in? Okay, cool. All right. So how do I make a gift from a Castle Trust to avoid the 5-year look back period? And this question actually just came up, not with who submitted it, but it came up earlier this week. I can't remember which client, not that I'd say which client it was, but they said it really cool feature of the Castle Trust was that you're able to make gifts from the trust. And why am I blanking on who it was? Oh, it's getting old stuff. But yeah, so here's the thing. So let's say we have a married couple. Let's say we have husband and wife, and they gift assets to the Castle Trust. Okay. The big advantage here is that, so what are the advantages of the Castle Trust? Starts a 5-year clock for long-term care / Medicaid. Because Medicaid looks back 5 years to see if you moved any money. And if you have, then they're going to penalize you. They're going to say that's a divestment. And now, even though otherwise you'd be qualified for Medicaid, they're going to say you don't qualify. So what you can do with the Castle Trust, though, is once you move the money into the trust, and let's say 5 years go by, depending on, then what you could do is you could make gifts to beneficiaries if you wanted. And because it was made from the Castle Trust, not from you, that means that it doesn't restart that 5-year clock, because the 5 years starts right here when you move the money into the trust. By moving the money into the trust, that's what creates the 5-year look back period. So this is the most important. It's not when the trust was created, it's when the money moves into the trust. So this is when the 5 years start. Okay. And then once you've made it the 5 years, then you can make whatever gifts you want, and everything inside of the trust is protected. So I remember it's some of my favorite people. I was completely blanking on that. But yeah, so yeah, it came up earlier. So they mentioned that, hey, you don't talk about this enough. So yeah, if you're looking to make gifts and you don't want it to trigger any type of divestment penalties or create any issues for long-term care or Medicaid, then it's great to set up the Castle Trust, which starts that 5-year clock. It builds in that asset protection. And then once you've made 5 years, then you can gift to whatever listed beneficiaries in the trust. And if the beneficiaries aren't listed, you could always make changes to the trust to add those people as beneficiaries. So yes, you would just make the gift directly from the Castle Trust. So question kind of continues, would it be from the key holder account? The answer is a hard no. We want it directly from the trust, because the key holder account, if you do have a Castle Trust, remember, it's kind of like just a joint account. So that means it touches your name again. And if it touches you, then it restarts the 5-year clock. Okay. But if it's gifted directly from the trust, it does not restart the 5-year clock. So yeah, very important. Don't gift it from the key holder account. You would gift it directly from the trust. All right, let's see. Do we have any other questions? All right, looks like we don't. So it was a quick one today. Thank you, everyone. Make it a great week. If you do have questions, feel free to give us a call. Interested in learning more, we have some upcoming in-person workshops. I think we have in the Livonia area, if I'm not mistaken. So we do have some upcoming educational workshops on estate planning, tax planning, and long-term care planning coming up in the Livonia area at Schoolcraft College. So if you want some more information on that, just give our office a call at 844-885-4200. Otherwise, thank you, everyone. Make it a great week.